for the convenience of our English-speaking colleagues, I will switch to
Human rights in Eastern Europe and Central. Stupnitska, I represent OSCE project coordinator in Ukraine. And our organization, as you know, does not have any soft law documents on business and human rights, but we are so grateful to Olena for having the opportunity to join this important topic through our legal education reform project to enable a wide circle of legal professionals to advance their knowledge and awareness in this theme. Today, my colleague would also present you some of our steps within our organization to promote this theme. Namely, last year we developed sustainable development strategy of the OEC project coordinator. This year we adopted gender action plan and strategy to promote gender sensitive working environment and culture. So we're really proud of having the opportunity to support this important topic. Regarding regional developments, it has already been covered partially during the first session, and we all know that global and the regional business models are changing rapidly, and there are a growing number of investors and consumers globally and regionally that basically demand more sustainable policies, more ethical business conduct, gender equality, and equal opportunities. It is, to some estimates, it's 450 million people worldwide currently working in supply chain facing constantly human rights violations. And in numerous EU countries, and not only EU countries, but other international foreign countries, we've already heard there are human rights due diligence legislation have already been adopted and implemented. And we also have numerous important developments in Eastern Europe and Central Asia, and it would be good to review the good practices, lessons learned, and the progress has been done in this area. So we would discuss how the national business and human rights action plans have been implemented. What are the correlation between the rule of law and status and the economic development? And you probably know that this spring the American Chamber of Commerce has conducted a study in Ukraine, and basically a lot of businesses, they pointed out that challenges in the countries were the main obstacle toward promoting the businesses in the country. And this session will be built in a way that we would hear in the first play the presentation of the key finding of the regional report on business and human rights in Eastern Europe by the authors of this report, and then you would have the opportunity to hear the interventions from the commentators. Now I have the pleasure to invite three key speakers to present the draft of the regional research. Beata Ferracci, President of the Board of the Polish Institute of Human Rights and Business, also Jerzy Letnar-Czernicz, PhD Professor of Human Rights and Constitutional Law, New University in Ljubljana, and Elena Uvarova, PhD Associate Professor, Head of the International Lab on Business and Human Rights in Yaroslav Mudry National Law University. So I would like to ask Beata Ferracci to start, please.
Thank you very much, and thank you again for inviting us to this space to share our, I wouldn't say it's a key findings yet, because we are in the middle of the research, and I'll talk about it in a moment. But I just wanted to start that now that we are kind of at 10 years after the adoption of the UNDPs, it's really the time to do some stock taking. And this is being done, as already Sinisha said, across the world. And UNDP is very actively involved in it. And Polish Institute for Human Rights and Business is currently having the pleasure to coordinate the work of myself and Jerzy and Olena concerning development of the regional study, scoping study on the level of implementation of the UNGPs in Eastern Europe and Central Asia region. And the aim of the study is to really assess and document the status of business and human rights in the region, but also it is to provide concrete recommendations on how to advance respect for human rights by companies in the region, both at the national and regional levels. Also some of the recommendations are meant to be directed to UNDP, but also to other international organizations active in the region. And because it's such a unique opportunity for us also to hear from you, I mean, we'll be trying to stay really short with some initial reflections so as to create space for the discussion. We'll have some excellent speakers sharing their views on a number of issues. And yeah, so we'll stay very short. And in a moment, I'll give the floor, pass over to Yevgeny and Olena to share their reflections. But from my side, as we are doing both the desk research, but also we are conducting interviews to capture some of the developments that are not written yet about. We come across some very interesting for example, for me, what was very surprising was that some of the actors that we would traditionally see as those who are, in my view, were a natural ally in driving the respect for human rights in business, are not necessarily trusted agents in the region. And one such group are actually trade unions, which have a very, I would say, complex history, if I could put it this way, also because of how they were affiliated with states in the past, with government structures, and how it kind of spills over to the current times. So I think it's very important to really listen to people on the ground, because if we just did the desk research, I don't think we would have came across some of those comments. So without any further ado, I would like to pass over perhaps to Yernay and then Olena to share your reflections. Thank you.
It's a bit early to deliver final conclusions of the study, but nonetheless, let me just give you some examples, perhaps of good and not so good practices in business human rights in the region, perhaps the region which I have been covering the most, which is Western Balkans. And let me start with pillar one, the UNGPs, so state obligation to protect. Well, there are some developments. For example, in Bosnia and Herzegovina, they just finished a baseline study assessment of VHR in Bosnia and Herzegovina, and it seems from the conversations I had with the experts there that there is a proposal for the draft national action plan with the federal government in Bosnia. So we'll see if this bears fruits. Then in Serbia, for example, this year a new law or the reform of the law on accounting was adopted, which includes obligation of for larger companies to report on non-financial indicators. But then, if I go on the other side, not so good practices. It seems that the governments in the region, they're not so much committed to adopting formal policies on national action plans on human rights. It seems that there's it's a bit of reluctance there, given the fact that all of these countries really try to attract foreign investment, and they don't want to commit themselves to adopt national action plans and legislation. Of course, as it has been said already this morning, the underlying problem of business human rights in the region, in Eastern Europe and Central Asia, is the rule of law. The rule of law is very weak institutions. In this respect, perhaps I could mention a good example of Albania, which in the last 3 to 2 years totally overhauled judicial system there. More than 100 persons who are performing judicial function there left the judiciary because they were not able to demonstrate where their property comes from. So that perhaps is a good example. Then concerning pillar 2, corporate responsibility to respect. So what companies do in the region? Are there any good practices? It's quite interesting that, for example, in Serbia is a country which has a large part of foreign investment per capita, perhaps the largest, together with perhaps Ukraine in the region. There, the reform is propelled not by the government, but by private sector. So there's a lot of investors from the EU-based countries, and they, through their supervision, global supply chains, they are also pushing for a positive change in business rights in Serbia. So That's it's an interesting observation, given the fact that the governments are not the reformers in the region. So the change perhaps is coming from the bottom, no? From companies and civil society. Then pillar 3. Well, some preliminary conclusions, perhaps, Beata, if you allow me, at least for concerning the Western Balkans. Yeah, the situation is not very positive concerning access to justice overall, and also in business human rights. People generally do not trust judiciaries in those countries. They resort quite often to the European Court of Human Rights. Then also there's a problem of persecution of human rights defenders and environmental rights defenders, particularly in Bosnia and Herzegovina and Serbia and Montenegro, where activists have been prosecuted when arguing for labor rights. If you ask me what is the role of national human rights institutions, so ombudsman offices and equality bodies, there are some good examples. For example, from Kosovo, which is Kosovo Ombudsman Office is a rare exception in the European landscape of national ombudsman offices because it has jurisdiction also over the private sector. But then, of course, there is a discrepancy between the practice and their normative functions. What also needs to be said, and what many interviewees said to me, is that often national human rights institutions are very close to the government in the region. So basically, they pay lip service to the policies of the government. This is the case, for example, in Serbia, perhaps also in Bosnia and Herzegovina. So they cannot really provide leadership in business and human rights. So these are just some examples of goods and also good practices which we found so far. We are planning to finish the study within the month. We'll have a draft, and then the final study will be presented at the UN Regional Forum on Business Human Rights in Central and Eastern Europe, probably mid-November. Sinisha told us today that they don't have the exact date. So with that, I'll stop and I'll pass the floor to Lena to add something.
Thank you very much, Єрний. Я перейду на українську.
I'll switch to Ukrainian. Also, a few small remarks which we have based on the results which we have already obtained. Several times it was mentioned by speakers about lack of trust or mistrust from the society to government and to certain institutions which have to defend human rights. We discussed the same issue at the regional session at our previous year session on business and human rights. It was a session on Eastern Europe, and one of the key features of the region is lack of trust in general to the governmental initiatives, governmental institutions, and it's a serious obstacle. And this mistrust is enhanced in those issues, in those cases when the government tries to propose tools of additional regulation. Though yesterday with our Belarusian colleagues we discussed and emphasized that the framework of business and human rights intuitively brings to strengthening regulation of business. Objectively, the government cannot regulate all those processes. We're talking about self-regulation level, but in the region it may be perceived with mistrust because of this history and the range of frustrations. That's probably cause of the barrier. Also, the experts with whom we discussed it in the region, they allowed us to cite them. They are talking. I personally talked to the Central Asia region, they usually say that economy first, then human rights. And in the situation when the economy is underdeveloped and not efficient, it's premature to talk about human rights. And the society agrees with that opinion. In a poor society, which depends on social payments, on the business position, it's difficult to talk about requirements on the side of the community to the responsible social behavior. And especially in Central Asia, they talked about weak um, public society and the government creates conditions when each citizen is feeling like they will find something what for bring them to accountability. It's not necessarily because of because they're activists, human rights activists. They can find some tax issues or something. In Tajikistan, they don't have open access to legislation, for example, and for a citizen and for small business, it's in principle a challenge. A challenge just to be aware, to know their rights and possibilities, and to not be afraid that something will not be initiated against such a person or company. Even the civil society, which is active, is mostly focused on political rights. And that's quite clear because there is a feeling that the government in the first place that squeezes upon those rights. Those individual activists who are working in the sphere of business human rights, they are persecuted. Even in Kharkiv here, we have several cases on defamation when companies against which the lawyers or activists are working filing claims on compensation of damage to reputation. We will discuss it in more detail today. The mining industry is very strong, and big business is also linked with the government. These are either the representatives of the sector are directly represented or indirectly represented in governmental bodies. And this close link is also a characteristic feature in the region. And in terms of the role on investors, for me, it was an eye-opener. In Central Asia, that the experts are saying that the influence of the EU and those trends which are taking place in the EU is weak. And the biggest impact on the region, absolutely everyone mentioned the Asian Development Bank and China. Their impact is the biggest, and so they orient towards their position in the first place. These are the preliminary results. It's not even the results. What we have heard from the experts and what we observed, and it will be interesting to discuss.
Thank you, Beata and Jerne, for the presentation. And I just wanted to briefly sum up this basically key challenges towards promoting human rights and business agenda, which are quite similar for the regional level, which could serve as a baseline assessment so that at later stage we could track the progress in this regard. So namely, it's a lack of leadership in promoting business and human rights agenda, lack of trust from society to human rights institutions, especially with regard to the overregulation and basically to the promoting new legal framework in this regard, discrepancy between practice and legal policies, and also human rights and rule of law challenges are the key stumbling blocks towards promoting this agenda, and maybe underdeveloped economy which prevails from focusing on the business and human rights agenda, and also insecurity of people, especially small business, such as, for instance, that's taxation mechanism, and uncertain legislation or unopened legislation that also brings to this uncertainty. And it was very interesting to hear about the findings of the impact stakeholders on the regional level level, which is also a very important finding. So thank you very much once again. And now, before we have a general discussion, I would like to open the floor for commentators' intervention. And we have small changes in the arrangement of speakers. And now I would like to invite to the floor Ms. Lira Yakovlevich-Yena, the Dean of Law Faculty of Mykolas Romerijus University. From Lithuania, and it's of course indeed would be interesting about regional developments since we have a lot of similarities and a lot of common background, so it would be very interesting to hear your intervention, please.
Good morning, dear colleagues, dear organizers of this forum, dear participants. Each year it's really a pleasure and great honor to participate in your forum, and congratulations on the 5th anniversary of the Legal Forum in Kharkiv. I would have wished to be with you today, but I know you have limited number of people that you can allow to be in presence due to pandemic situation. So thank you very much for allowing me to still speak to you in this way. Now, what I have been asked to do is to comment on preliminary observations of the report, of the research, in which, unfortunately, Lithuania, neither the other Baltic countries are present. But when I hear what you say, it actually reasons a lot with probably what I'm going to say. And also I was asked to comment maybe briefly on what would be good still to include in the report. So I'm really glad that there is still a room for some points of research to be included. So let me start maybe from a little bit far, but I think this is the essence if we speak about the trends and about the situation in our region, and I'm talking more about Lithuania and the other Baltic countries, is that still for many years until now we're talking about lack of awareness and lack of competences within businesses on human rights issues, which is on one hand quite natural because this is not their business, but the understanding of the topic itself, business and human rights, is really very much diverging. And this also lack of single understanding or common understanding, that this leads in practice to several problems, including the engagement of businesses, and I will explain what I mean. Now, you are lucky in Ukraine that some years ago you have carried out a baseline study as such. Now I understand it's one of the objectives of this regional research that is being undertaken. In Lithuania, we have carried out, and in our region, some time in 2007. So at the moment, we don't even have the base analysis of the baseline situation, which actually is quite an obstacle when we try to find a common language of what kind of problems are we talking about. The trade unions are talking about one kind of problem, the businesses are talking about different type of problems, and government is talking about something else. So I think it is very important, and I would encourage everybody who has not carried out yet baseline studies, including also ourselves in Lithuania, to actually start from there, because that also helps to promote some of the measures that the government is undertaking in this field. A second point that I wanted to make, and this reasons a bit, sounds a bit what also Cherny was saying in the presentation, but maybe a little bit broader, that generally there is not only lack of trust in let's say, judiciary, not because the specificity of our region is that judiciary is independent and the problem is not there, but simply the general population, the employees, they believe that companies are so powerful that actually they will be able to better defend their positions, their rights in the courts. And at the same time, as we don't really have very well developed public interest defense, meaning that our General Prosecutor's Office does not really have particular competencies here in terms of human rights issues in businesses, the NGOs are really mostly focused on their own, let's say, narrow areas that they are working with. So when we have this lack of developed public defense possibilities, then it becomes quite difficult for individuals to litigate against businesses. And that's also the reason why they don't bring cases and why cases do not reach the judiciary. So we have this type of lack of trust in judiciary, but not because of lack of rule of law, but because of other aspects. Now, the third point that was also mentioned already by Olena and also by Beata in their presentations is how far we should regulate. And indeed, when we speak about the business and human rights subject, what exactly we mean? Do we mean a better performance of current regulation? And it has been already mentioned that in this region we have a tradition of over-regulation. So there is already a lot of national regulation, international regulation. There is really sometimes a big confusion both within the business sector, but also within the trade unions, between the among the government institutions. Now, are we advocating exactly for better implementation of current regulation, or are we promoting something which is a new regulation? And it is quite confusing. This point is quite confusing for businesses, first of all. Now, there is third element. Are we promoting something that is still expectations, like we're talking about due diligence that is to become a legal act, a mandatory legal act in the European Union? But is this something what we are propagating? So to reflect on what Beata was saying about trade unions, I have exactly the same observation, that it was a surprise actually that trade unions were not so quick in jumping on this topic and being an allies. But on the one hand, I understand why, because they are afraid that promotion of this topic and something more than just existing legislation, new regulation, or even expectations that is still not part of regulation, that it might dilute the attention from the present problems of implementation. Because the implementation of current instruments that are part of our labor code, part of national legislation, is lagging behind as concerns the business implementation. So on this part, I think they are a bit right. On the other hand, I support very much what Olena was saying, that indeed in this region, when we don't have so long traditions like in the Nordic countries, for example, for social dialogue, for so-called social capital, it would be very difficult to achieve any kind of progress if we go through just self-regulation and not mandatory new regulation. So in that respect, I think there has to be some balance, but it's also very important also at national level when we promote in the context of national action plans, plan developments, or generally in the discussions and promotional activities, that we clarify what we mean. Do we mean existing regulation? Do we mean new regulation? Or do we mean something beyond the regulation? Now, of course, business prefer less interference because they consider this as additional administrative burden if there is a new regulation coming up. And I believe if we would go for more regulation at national level, at the European level, then, of course, the issue of capacities needs to be addressed, because, as I mentioned in the beginning, it is a challenge, in particular for the small and medium enterprises, to carry out a due diligence process, because they simply do not have people and capacities to do that. So I think any kind of support in promoting these activities has to go hand in hand with the support for capacities. Now, fourth brief point that I would like to mention, and I think this is tendency not just in our part of the region, is that business and human rights being an interdisciplinary subject as such, of course, suffers in the same way as other interdisciplinary fields, suffers from limited interagency coordination when we speak about national institutions and their engagement in promoting this topic. So I think it would be very important in the research that is being carried out to maybe, if possible, to look for good models, good examples, or good practices of this interagency cooperation, because without good interagency cooperation at the country level, it would be very difficult to speak about the effective role of the state to engage businesses, and also to speak about effective implementation of national action plans. Now, the very, very last point, which has not been mentioned here, but I think it could be one interesting point, not sure if for current research that you are undertaking, but clearly for follow-up, is the whole effect and impacts of the COVID pandemic on our subject, and in particular on the situation of businesses. So while previously it was quite difficult for some businesses to understand what we're talking about when we speak about human rights, because they consider that in our part of the region, everything is fine, all the obligations and implementation exists. But during COVID situation, there were a number of issues. For instance, use of all kinds of equipment for monitoring the COVID patients, their movement, and so on that were proposed. There was immediately an understanding what we're talking about, and because businesses were also very much involved in developing of apps for such monitoring and so on, then immediately it was quite clear what kind of human rights issues we're talking about. So I'm just, as an invitation, I would like also to finish by proposing to maybe in the future to look also into this issue, because there could be some even more negative aspects of the issue, but also there could be some good practices in that respect. And it's easier to observe human rights in the situation of peace. And we see that there are additional challenges that are raised by the situations of emergencies, extraordinary situations like we have right now. So I stop here because I know the time is limited. If there would be possibility to say a few more words in the discussion, I would be happy to, but I stop here.
For your intervention and for pointing out so many important issues, such as the need to have baseline assessment of the situation on business and human rights, and also for complementing with such important points as observed by the region as the lack of trust and stereotype of people, as to their ability to protect their rights, and the role of civil society in this regard, and also the difficulties of litigating the business related to some extent to the independence of the judiciary. You also pointed out the important issue of regulation versus over-regulations and implementation of the current legally binding documents. And also the importance of coordination on the regional level was also mentioned, and sharing the good practices in this regard, and as well as follow-up pandemic-related trends on the business and human rights. Thank you very much. And we are now moving forward, and let's turn to the experience of Belarus. We have two commentators who will be speaking at this session. Is Oleh Kulak, Belarusian Helsinki Committee, and Ekaterina Deikala, PhD, Associate Professor, Expert on Business and Human Rights in Belarusian Helsinki Committee. And I have a question to Oleg and Katerina. Basically, Belarusian Helsinki Committee could be named as a champion in promoting business and human rights agenda in the post-Soviet space. And your organization, your committee, was the one who developed business and human rights country guide. And you were also the first who have started to work with business on with companies on business and human rights agenda. And you developed different tools for business, how to promote this topic and also worked extensively with civil society, also with international stakeholders such as Lund University, Danish Institute for Human Rights, and many other champions in this sphere. But could you say that your country had the progress on business and human rights agenda during the last 5 or 10 years? And what are the key barriers that should be reflected in the regional research in this regard? Thank you.
Добрый день, я буду по-русски.
Good morning, I'll speak Russian. My Ukrainian is not so good, and English as well. I apologize for that. Thank you for introduction. You mentioned our extensive and long work on business and human rights, and I believe how should I answer your question quickly? Do we have the progress? And I cannot answer this question briefly because at the same time we have interesting processes and we have regression from the governments, and at the same time the business is getting used to the new trends and new trends are promoted as the communities, which is also an important player, important stakeholder in this field. And this undertaken, the community receives the impetus for development. I'll try to discuss this further with Katerina. And first, I'd like to discuss the governments. Of course, the topic of business and human rights is directly related to the relationships with the human rights as such. Unfortunately, in our country, our government is distinct in terms of the wrong attitude to human rights. Our government sees the threats to themselves from this topic, and this may be correct actually. So there's more or less active counteraction to the human rights activism, to human rights organizations, and to the words of the phrase itself, human rights. This was strongly politicized, and it's prevented the promotion. When we had the research, when we worked with the business, immediately it was visible that the topic itself is frightening by being perceived by the business as political, as the issue of attitude to the government, and this is dangerous, and this was the barrier. Very often it was mentioned that if it is called differently, rule of law, it's okay, it's normal, something like that, which is positive, and this may make loans cheaper. This is interesting to us, but you should not call it that terrible phrase. And over the last year, since August, maybe even since spring last year, the country was in political campaign, presidential election, and all these processes got more severe, and this had direct impact on the business and human rights. Why? Because the governments, the authorities tried to use their capacities to influence all those under their jurisdiction, to reinforce, to preserve their power. And for this, in Belarus, we still have many Soviet instruments which are non-existent in Ukraine and other former Soviet Union countries. They are not available to the same degree, at least. We still have the Soviet elements in our electoral codes. Labor teams are the entity in the electoral process. They create election commission. They are involved in the creation of the election commissions, in campaigning and political campaigning processes. And so there is great temptation to use the power to use influence on business to make business subdue, to use capacities to influence the state-owned enterprises, to influence the needed results of the election, to make people with instruments of the labor law contracts, term contracts, to make people comply with what is required from them. And now we finished the preparation of policy paper on the post-election period, where we try to demonstrate this, first of all, to focus on this issue, to show this to Western businesses, to European businesses, which are interested in coming to Belarus, and Belarus business is interested in interacting with them. We would like to show the risks for the business which exist, what are human rights violations in the value chain that may appear because of the system in the country. I understand that for the person who is used to doing business in the normal situation, they don't see those things, and it is not visible immediately. You need to go deep into the situation to understand that. This is why this was our objective. And in this period, the labor legislation has deteriorated in the area of rights for strikes, ability to fire employees for leave, to make the employee more enslaved, and this was actively used in practice. And now when the political heat has decreased, now the business, when employing a person, requires from employees to show the information if you were convicted, you or your relatives, and give the permits to verify the situation. The person is supposed to give the approval that the employer can send a request to the police and to get the answer if the person was convicted. First of all, this is some administrative offense for some opposition activity. This is what is meant. These are the forms of influence to make sure that the person cannot freely express their civil and political rights. This is why we have violations of this social and economic rights. Also, we mentioned the role of the trade unions. Beata was talking about this, that trade unions ideally should be allies in implementing these standards and guiding principles, but we still have this Soviet heritage. The way it was in the Soviet Union, the trade unions and the School of Communism, the trade unions are the governmental federation. They are fully controlled by the government, and they were one of those who were campaigning for the incumbent president. They were so-called authorized persons of the president, and they did not perform the function of protecting the employees. It was the opposite. There were additional instruments of influence and control and counteraction to establish independent trade unions that would really protect the employees. This problem was very severe. we tried to compile the approximate database on these cases, on violations. We describe the cases, and the picture is sad. The country made huge step back towards the repressive side, and this is bad. But against this background, Katerina will tell us more specifically about this. We have seen the activation of the society, activation of our diasporas, and in the public there is strong demand to protect their rights. And this is the positive development which should be used further. Thank you. Colleagues, I'll also speak Russian. As I'd like to communicate important things in the structured way, it will be easier for me to do it in Russian. First, I'd like to say that, to continue on what Oleg said about the role of the government, it's very important to say that there's a general message in the topic of business and human rights. How to protect the weak governments from the bad business, which has strong influence right now and which violates the human rights and goes beyond all normal behavior. For our region, Eastern Europe, and I'm talking specifically about Belarus, there is a huge problem of what should be done if the government, if the business wants to do due diligence, to follow, to observe human rights, and foreign business which comes to the country, they want to act responsibly, but the government represses the business for doing that. The situation is with China. It is very indicative with Xinjiang cotton, when we know that
закупать синьцзянский хлопок.
Xinjiang cotton, some measures were taken against them by the government of China. They were prohibited to be mentioned on TV. Their brands were diluted on TV, and so on. In the case of Belarus, we had a very indicative case when the Skoda refused to sponsor the Hockey World Championship organized that should have been organized in Winsk in Minsk. There was strong pressure on the society, and the society did this actually using the diasporas. And Nivea and Skoda refused. Skoda was the main sponsor for many years, and they refused to sponsor the events. And as a response, the government of Belarus prohibited the imports of Nivea and Skoda goods to Belarus. And so we faced the problem, and they argued this in their resolution as due to unfriendly actions towards the Belarus people. And we face the situation that after this, when the same pressure was applied to a number of international brands like Nestle, L'Oreal, Nestle especially, they were supposed to remove their advertisement from the state's TV channels, because 1/3 of the advertisement at state TV channels is the advertisement of Nestle in Belarus. And this is one of the channels. Here we need to remember that state channels are media business. We look them in the context at them in the context of our topic as the media business, which violates human rights. They have propaganda, they have incitement of differences and so on. So Nestle and the rest of the corporation seeing this happening with Nivea and Skoda, of course, they start to think about this. now we're going to do this and what will happen to us. Because anyway, this is the issue, and then we have to understand that the topic of business and human rights is not about business stopping doing business, because business is really needed, especially in the countries like our region, because the business develops the economy and the entrance of the foreign investors is strongly needed. So we have this dilemma, and these companies start to think about this. And the second point on the business itself, how the consequences of all this, that's like I said, all except the government's creating pressure on business, the attempts to use business as instruments to violate human rights. This leads to the situation that business, which is the most progressive in Belarus, IT business, for example, which creates the framework which can be the model for others. This business has to leave the country because we have some numbers in November. We had the research on the opinion of the business and the attitude of business to the situation. And we can tell that 40% of the companies see the risk. They include this into the risk management system, the threats of personal security and risk of detention of their employees. This is part of their risk management system. 39.7% see the risk of outflow of qualified staff from the country. And if I talk about industries of business sectors, according to the survey, in which sector the business is the most concerned, this is IT business, the business which is closer to the standards, which uses the standards, which complies with the standards, which has human rights due to specificity of activity and due to human being being their main capital. And if you don't create conditions for people, the people will just leave the company. And this is the first point, and it is the first problem. And the second problem about the society, as Oleg mentioned, any phenomenon has two sides to it, black and white. And of course,
точкой входа для более сильного распространения темы в Беларуси. Почему? Потому что бизнес и права человека — это не только про давление сверху на бизнес, но это про запрос снизу от общества. Если общество не спрашивает со стейкхолдера, то какой бы это ни был хороший стейкхолдер, он рано или поздно будет скатываться в сторону как бы нарушений просто прав человека. И поэтому в данном смысле можно сказать, что белорусское общество...
So the Belarusian society really woke up, and that there are two big factors which influence that. These are absolutely breakage of the social contract with the government during the pandemic, when the government failed during the pandemic and started accusing people, and very strong and tortures and very rough treatment in detention centers. So those factors, when combined, gave huge impetus. The people started to feel as subjects, bearing rights and they're paying taxes and everything which taking place there was at their expense, actually. This was a key to promote this topic further because those marches during the protests, there were many slogans saying that we are paying taxes, we are paying you, you are torturing us at our expense. So this point is that those demands, those requirements to the governments were extrapolated immediately to business. And the state-owned business, as Oleg mentioned, is actually an equivalent to the state, to the government in Belarus. It's not independent. It cannot make independent decisions. But the employment percent, actually half of the employable population, I don't know if I'm using this terminology correctly, they are hired by state-owned enterprises. And the share of state-owned enterprises in terms of number is not that big, but they're huge. That's why they hire a lot of people. And as a result, the indicator became, first of all, people started to get interested. What are their rights in terms of civil and political rights? What's important that the situation in Belarus showed a very close link between political, economic rights. When they try to suppress demonstrations, that the government told them that you are striking legally because you are setting forth the political requirements, not the social ones. But International Labour Organization, when they considered the situation, they described in detail that these rights are violated because you don't have access to civil and political freedoms. That's why this strike is within ILO standards. It cannot be illegal. And this is very important for those who talk about it as economic and social rights. There are a lot of economic and political rights. And our last point is that there is a demand from this side of the society. There were several applications created, 4 of them. The biggest, these are databases of those businesses which violate human rights. Many of them highlight affiliation with the state, some of them about violation of human rights. These are applications and websites, IT products, which demonstrate this mechanism of naming and shaming. When you scan the barcode on a good, it shows you what is this company. There is no study which show the drop in demand for certain goods because of those applications, but there are some indirect evidence. This also provides an opportunity for further investigation and study. Thank you very much for sharing, and Oleg.
Politicization of human rights agenda and perception by business that the topic of human rights is dangerous and highly politicized and existing outdated instruments applied by business. It was mentioned the instrument of identification of possible change of human rights violation by the businesses as a very important instrument for pre-identification of potential threats. Also challenges related to business striving to promote human rights agenda, but at the at the same time, the state trying to suppress such efforts, and it was basically a huge hope was put on the responsive society, and basically the growing demand from society to make business responsive to human rights. So thank you so much, and we need to move further. And now we have also small changes, and I would like to give the floor to Artem Vlasyuk, representative of legal business. Artem Donets. Oh, sorry. Artem Donets. Yes, the advocate and the head of the leading partner of the advocate company Donets and Partners. Please, Artem.
Дякую, колеги. Якщо можливо, до
Thank you, colleagues. If possible, before I start the presentation, I would like to ask Katerina Kalayu. I mentioned a very interesting moment about this IT product, which allows to check the producer. Were there instances when the company provides directly or indirectly provide services to the government, and they stopped doing so because of repressions and suppressions by the government of human rights? Well, if we are talking about the state-owned business, no. Again, the public procurement issue has its specifics here, because not human rights lovers get there, but lovers of the state, of the government get there. No. Okay, Oleg will supplement. The point is, the business which is there in Belarus, it depends very much on the government. It's this is the issue of the existence of the business and personal security of people. There is IT business, PandaDoc. They created the fund of helping the repressed people, and half of their company, several of their managers were imprisoned, and the rest had to leave the country. And just a month ago, they were released. They spent in prison about a year. But the business which is not in Belarus, which brings something to in Belarus from abroad or buys, those businesses behaved differently. Interesting experience. The Belarus diaspora contributed the organized pickets. They attracted the media and broke with trade unions. The businesses, Western businesses, behaved in different ways. Some said that if there are sanctions, then they will refuse. Some, like Nivea and Skoda, were more sensitive. There was an interesting case. The best well-known, the Norwegian Yara, the fertilizer producer which buys from Belkali. This is potassium fertilizer. 50% or 30% of Belarusian export is potassium fertilizer, and this is the big buyer of these products. In their contract with Belkali, the human rights were reflected, and there was a trilateral commission created with participation of trade unions of Belkali and Yara, and they reviewed those cases of dismissed people and prosecution for political position. This was an uneasy process, but there was an interesting experience how such issues could be solved. Now the sanctions are expanding, and the issue of due diligence on human rights is more and more related to the threat of getting under sanctions. This combines two different notions. This is also an interesting topic from the standpoint of discussion, and we promoted this topic as a tool of influence on specific businesses and specific. We are not interested for business to leave because it will be difficult to get them back, but we're interested for them to make influence, and this is a tool which can be used for influence, not in a revolutionary way, but in some ways. But many people want to make it fast, and let's introduce sanctions, and business will leave. This is a discussion between diaspora and trade unions. At least we have information to analyze. I hope we're did not change the agenda too much because of my question. I would like to talk about responsibility of business and following and adherence of businesses to requirements of human rights. Yesterday I touched on this topic a bit, and I would like to get in more details today. As person in Ukraine, well, aware of this topic. Now we are introducing amendments to the labor legislation. The law was introduced, which enabled Dia City application, which would influence the relations between employers and employees. It's a well-known fact that at the moment in Ukraine we have a labor code in Ukraine, which was adopted back in the, or which was drafted back in the Soviet Union times. It's quite outdated and inefficient both for employers and for employees, unfortunately. At present, the most advanced sectors, I mean the IT sector, which in this or that way is related to creating media contact. They are working on gig contracts. What are gig contracts? This phenomenon came here from the West, as many other things. This is a model of building relations between the contractor and the employee. It's a free scheme when the employee provides services as independent vendor or independent provider. This came from the United States, this model, when musicians, creative persons proposed their services to bars and restaurants where they made gigs or performances. According to this model, the whole sector of IT is operating in Ukraine. And in opinion of the previous government, current government, it is like a gold, as a gold egg layer, and this was exploited for many years. In terms of taxation, tax rates, and organization costs, it's profitable, though this scheme allows 2 or 3 times savings on taxes, creates certain weak guarantees for the provider, for freelancer. At the same time, all those risks for a person are leveled by the successive policy of the employer. So, in terms of topic of my presentation, unfortunately, we faced several years ago with a case when the big transnationals, when they came to Ukraine and using this gig model, when they're working with the employees, I was thinking how to describe it. They started exploiting not only the benefits or two-sided preferences of this model, for them and for the employees, but only what allowed them to get considerable savings. And if the condition changed, they refused the services of those employees. I won't name the company. It's well known. It has a representative office in Ukraine, and they provide courier for services. And because of a number of negative events, these were road accidents when people died or were as injured, they refused continuing contracts with those people because they were not hired as employees or as individual entrepreneurs. These were just as people who registered in certain app, provide services, and that person died, and that's all. And we just refused. Unfortunately, our lawyers came across this problem not once, and at the moment there is a number of criminal proceedings and civic proceedings in Ukraine which persecute the same aim. When European business come to Ukraine and declare high values, have to not only declare those values, but be socially responsible. And if according to, for example, national legislation, that courier was using a bike, was driving on the highway, and was not obliged to have a hard hat, helmet, and the company has to require higher standards if they join such a service. We started public discussion, our lawyers community, and we were looking for such avoidance of responsibility, and we're looking for witnesses of such kind of work, and we got the claim on defamation to recognize that, to acknowledge the information as incorrect, and it was it was popular to say that the government is the biggest violator. Now we are on the brink that when the transnationals will become the biggest violators of human rights, and the governments will not be able to do anything. And in that case, the state fiscal service and other agencies said that we cannot do anything. We have filed them requests and they do not respond. We require documents, they don't provide those documents. And we cannot prove that they violate legislation because we don't have evidence. I will not comment the actions of those governmental agencies, but in such situations, the community influence and pressure and is on the way to solve the situation. In addition, the lawyers community in the internal communication, in horizontal collaboration, which was discussed yesterday, is the only driver of changes. Because human rights, it's like a bike. When you push the pedals, you drive, you ride. If you slow down, you fall. With the human rights in our country, the transnationals became very important, and as long as we as users of services will use the services of socially unresponsible companies, the state agencies will not respond. The situation with human rights, unfortunately, will only deteriorate. And here, I would like to thank our colleagues from Belarus again for your experience, because we are close to you in terms of observing human rights by corporations. That's why I was curious how business reacted to those events.
a complicated case that there is basically the issue of the role of transnational corporations in ensuring human rights compliance. And now we need to move further because we are running out of time. And now I would like to give the floor to Ms. Ella Skibenko, Eastern Europe, Central Asia researcher and representative at Business and Human Rights Resource Center. And I would like to ask you the question, Ella. When we are talking about regional research, it's important to know that basically cross-cutting issues or regional trends and the unification of such trends. And do you agree with the authors of the report and presented research on the trends that they mentioned and outlined as regional?
Дякую, Наталя. Доброго дня, шановні учасники панельної
Thank you,
дискусії.
Natalia. Good afternoon, dear panelists. Before I start talking about regional tendencies, which our organization sees, and cross-cutting issues, all movement of business and human rights is formed under influence of three key drivers of violations.
Так буде легше просто сприймати інформацію. Перше, це
I will show the presentation. First of all, the inequality of power and wealth in the community. Another driver of violations, deficit of management, unresponsible management, and the third driver is climatic crisis, which is caused by irrational use of natural resources. Under the influence of these three drivers, the regional tendencies are formed. The first tendency which I would like to mention, to discuss, is the model of maximizing profit. This is a business model of maximizing short-term profit, which we often see in the region. How does it influence human rights? In the first place, it deprives people of power, and it serves the interests of certain individuals or privileged groups, and it externalizes environmental and social costs, which in that term result in inequality and environmental climatic crisis. Most mining businesses in our region use this model. I hope we will see the presentation on the screen. I would like to share the results of this study, which we conducted among 30 biggest mining companies in Armenia, Georgia, and Kazakhstan. And what we have done, we assessed their policies or obligations and practices. And the aim of this study was to draw attention to risks and the consequences for human rights in the mining industry. Why mining industry? Because this is one of the biggest sources of violations in Eastern Europe and Central Asia. Here we're talking about dangerous working conditions, various abuse and violations of labor rights, and negative impact on communities and environment. So this is the model of maximizing profit. Digging in the Shadow, that's the name of the study. It's published on our website, both in English and Russian languages. I would like to mention a few words about the methodology. First of all, we would like to use the well-known method of corporate human rights benchmark. This method is focused on the policies, processes, and practices of the company and how they respond to serious accusations and This is based on public information provided by companies themselves, but as some of those companies don't have even their websites, especially in Georgia, we couldn't use this methodology, and we decided to ask people and circulated questionnaires. But despite of our efforts, first of all, we got only one answer. That's why we decided to use various resources, non-government organizations and government agencies. We collected all information, created company profiles, which contain all accusations against them and their declared policies. As you can see, access to information appeared the first big problem which we faced. Out of 30 companies, 8 didn't have any information on observing human rights, and 22 companies had problems with accessing the information. A few words about the results. In total, we have identified 167 problems related to adhering to human rights in all 30 companies. 25 companies out of 30 were accused of violation of environmental and water resource rights. 22 of them faced with the problems of accessing the information, also health and safety and other problems, means of existence, adequate level of living. And 20 companies were found to violate cultural and property rights. The companies which were found guilty in violating by categories, I won't focus on those because of lack of time, but we have seen as a result of this study, it demonstrated a huge gap between the companies' policies and practices, or their obligations which we declare. Because some companies, yes, the majority of companies had declared policies, but at the same time, very serious accusations were filed against them. And in practice, so they promised some things, but in practice it was quite different. And a few words I would like to mention a few about the owners, investors in those companies. At least 12 out of 30 companies gained support of investors from US and Europe. In the first place, this IFC and this World Bank Group, and also the companies from Western Europe, Canada, and US. They have shares in 16 out of 30 companies. Corporate curtain creates a huge problem for lawyers and activists. Often the parent companies are hidden behind the range of subsidiaries, and often it's not clear who is the final beneficiary or the owner of the company. Here we can see the structure of ownership of two Georgian and two Armenian companies. As you can see, they consist of the chains of shell companies in various countries. You can find more information about this study on our website. You can see the interactive map who are investors and what are the violations they are accused of. And very briefly, I would like to mention the next tendency which we can see in the region. It's a restriction of human freedoms in authoritarian countries. We can see the growth of the prosecution and violence.
Казахстані саме цих правозахисників,
For example, we analyzed the persecutions against human rights activists in Kazakhstan, or those human rights activists who work with business and human rights. Over the last 5 years, we recorded 693 cases of persecution, and in 50% of cases, the government was directly involved, unfortunately. Also, very often the companies which operate in authoritarian countries fully ignore the human rights violations from the governments. The bright example was mentioned before with the situation in Belarus. Similarly, we apply it to 55 companies which still cooperate with the government of Belarus, despite what's going on in the country, with the call to take immediate action. We received only 22 responses, and the answers were like, we are really concerned, or we follow the standards. Some companies promised to carry out investigations. One German company, an official answer says that the money doesn't stink, and this answer is published as the position of the company at our website. Only one of these 55 companies, Michelin, really decided to do something to improve the situation at the factory with which they cooperate, not directly but through intermediaries, but anyway, this was the only company which really does something to change the situation. Next trend, I'll not discuss it because it was mentioned before, is the influence of the pandemic on human rights. It's not a secret to anyone that this is negative, and the pressure on human rights activists is strengthened. Unfortunately, many companies and governments in the region use the lockdown to increase the pressure on NGOs and human rights activists. They continue to do so. Also, we observe that there is ongoing increase of the number of strategic lawsuits against the public, so-called SLAPs, that are filed. We have heard the case of a European company working in Ukraine, which files lawsuits against activists and NGOs, which accuse them of violations. The next trend is ongoing technological development, which increases the risks for human rights. We all have heard about the project, Pegasus project, where the governments of 11 countries, including our region, the governments of Azerbaijan, Kazakhstan, and Hungary, tracked the representatives of NGOs, human rights activists, journalists, using the special software. And some journalists were even murdered as a result of this tracking. Another problem is internet shutdown, which regularly happens in Russia, Belarus, Kazakhstan, and other countries, unfortunately. Also, accusation. More and more often we face the accusations by the companies in providing the confidential data about their clients to the governments. Mostly this is about cell phone operators, mobile operators. One of the cases we worked on, that case was in Belarus, when the mobile operator A1 was accused of transferring information on their clients to the government. Very quickly about cross-cutting problems of the region. I'll not discuss this at large. It's lack of awareness and understanding in business and human rights among all stakeholders. Also, poor work conditions, attacks on human rights activists, low salaries, unpaid salaries, environmental pollution, forced labor, discrimination, unstable employment. And not to finish the presentation at some negative note, the last slide is dedicated to the potential positive trends in regulation which are going on at the moment in the European Union. This is adoption of mandatory human rights and environmental due diligence for the companies. We have hopes that these changes in the EU will have some positive impacts on our situation in the region. Thank you for your attention. I hope I did not exceed my time.
Regional trends, I just outlined so many of them that I wouldn't just repeat and sum it up. And I'm sure that we'll have a chance to discuss it in more detail later on today. And now we need to move further to our next speaker. And I would like to invite the four representatives of legal business in Ukraine, Vladislav Lasyuk, partner and founder of the law company ePravo. Please, Vladislav.
Що я це не бачу, щоб він з'явився. Ми почекаємо ще.
We don't see Vladislav connected. Let's wait and let's go on according to our agenda. Mr. Bogdan, I'll announce that Mr. Bogdan was involved in joint research on with Oxford University, which covered 16 jurisdictions on civil legal responsibility in the context of business and human rights. And this is one of the complicated legal problems which characterizes the region. Bogdan, please. Thank you, Lena. I'll stay in the area of my expertise and I'll say a couple of words on delicts law of Ukraine in the context of the third pillar of the guiding principles. The third pillar is saying that the individuals have to have access to the efficient remedies in case of violation of their rights. And I asked the question, can Ukrainian delict law serve as this efficient remedy against business cause violations of human rights? And today, my answer is that the potential of the delict law is used not fully. Again, I'm talking about Ukraine. For this, there are several reasons, several obstacles why delict law cannot fully serve the purpose of efficient protection of human rights in this area. I will quickly mention them without taking too much time. The first obstacle is that in Ukrainian delict law, there is no developed concept of bringing to responsibility for indirect involvement in violation of human rights. That is, within a parent company and subsidiary, or ability to bring to responsibility of the producer of the final product for violating human rights violations committed by the supplier of the feedstock. This opportunity is very limited according to Ukrainian delict law because there's principle of personal responsibility. Everybody is responsible for their actions and no one can be responsible for actions committed by someone else. This is the first point. And second point, as it was proved, the number of provisions of Ukrainian delict law is not effective. Although they are outlined in the code, they are not really working. In particular, this covers the right for reimbursement for the house and ruins in the area of anti-terrorism operation. As this, I'm not sure it involves business, but we have the law which says that the individuals whose housing was ruined in this area have the right for compensation at the expense of the government. And our courts ruled that this provision is too general, it is too abstract. It doesn't give legitimate expectations to people, it doesn't give them rights to count on getting something. This provision is not effective until we adopt some special law, which would elaborate this and explain how this compensation should be provided. And the third point, I believe that our teaching on the conditions of the delict's responsibility is very unflexible and unmodern. In particular, very often the stumbling block is proving the causing link, in particular in cases related to environmental pollution, harm, because to prove that some disease of the specific individual is caused by this air in this region, it's almost impossible. And given the status of development of medical science, and in many countries there are mechanisms, there are ways of weakening the burden of proof which lies on the claimants on these cases. There are attempts to make exemptions for specific cases. There is a way of reversion of burden of proof that is putting it on the violator of the rights. We stay non-flexible in this. I'm convinced that our theory of causal link is not developed, and the researchers and scholars are to blame, me in particular, but I decided to do this, and hopefully it will deliver fruit. Our next reason is that we don't have the class action instruments that would allow to accumulate the claims of many claimants and to simplify their access to the court. Also, we don't have the class action instruments, and we don't have the general culture and awareness of people that their rights can be protected, especially with regard to environmental cases. Although the law envisages that the individual has the right for compensation for damage caused by polluted environment, but if we look at the register of court decisions, the suits on the basis of this article are filed by the State Environmental Inspectorate to collect the reimbursement in favor of the state. The citizens do not apply for protection of their rights. There are only a few cases. One was on the fire at the oil base near the Kiev, at the tank farm near Kiev, and so we have only a few cases related to these. And the last point, I'm not sure about this last point, but just for your consideration, I'd like to present this. Yesterday we discussed the incentives for producers to comply with human rights. I was always struck that the amounts of claims in the countries of general law in the United States and UK, when they reimbursed 100 million, or in March 2020, there was 1 billion in favor of the family of farmers to use herbicides that proved to be carcinogenic. I was always struck by these numbers, and the way that I analyzed this is so-called punitive damages instruments, and I believe that's one more incentive for the producers to comply with human rights is implementing something similar, because the previous speakers mentioned this. The producer can just calculate a year I pollute environment and I cause damage to 10,000 people, but 10 people go to the court, each one will get 50,000 hryvnias, and I'm still in profit. I will continue violating. This will still be profitable, but this is controversial opinion. I'm surprised by the numbers collected in the Anglo-American systems. Thank you. I'll not exceed my time.
Pleasure. I would like to give the floor to Igor Konopka, human rights lawyer. He deals a lot with human rights due diligence issues, and as you all know, it's currently, as we've been discussed today, a key trend in EU countries, and we believe this trend could also cover the region.
First of all, thank you to Elena for inviting me to this amazing event. I'm so excited to be here for the first time. Just 4 months ago, I was writing my thesis about prospect of mandatory human rights due diligence in Ukraine, and I was describing this forum as an engine of this bigger agenda, and now I'm here. That's great. I have several points. I believe that this trend can be followed in Ukraine, and when I did my research, I found out that, in fact, those concepts which are a foundation for human rights due diligence, including the transactional due diligence, which is very familiar to businesses, including in Ukraine, these concepts, they also appear in various legislative acts in Ukraine. And for example, we can talk about due diligence in anti-money laundering legislation. We can talk about anti-corruption due diligence. And even though the aims of this legislation, they are different, but the underlying principles are basically the same. It's about prevention of harm. It's about having some kind of program or strategy or a policy to fight these issues and have a person who is responsible for this. Moreover, we have, as Bohdan already mentioned, we have delict law, which is quite different from tort law in some Western European countries. But at the same time, I found that some features of our delict law can be used, and as Bohdan told, it has potential. So we should explore it more. And in particular, I'm talking about civil liability, delict liability, and labor-related delict liability, environmental related delict liability, and discrimination-related delict liability. All of these tools, they should be explored further and used because they really have a potential. Second point is that when we talk about EU and the trends in regard to mandatory human rights due diligence there, we need to keep in mind that it's not just about corporate due diligence and corporate accountability. This is a part of much larger comprehensive system. And this is truly, truly important because in EU, they started with, not started, but they recently launched this EU Green Deal. And they have various directions of developing legislative acts, and this due diligence, it is only one. We also have one on sustainability reporting, which aims on developing and updating non-financial reporting standards. We have also sustainable corporate governance, which is believed to be as well important as corporate due diligence and other measures. And all of these measures, all of these instruments are aimed to meet the aims of this EU Green Deal. So we should keep that in mind. And what I also learned about Ukrainian legislation, to my surprise, that in fact we have other acts where we mention very related to HRDD processes issues. For example, we have now we have this effort to reform civil law. We have a recodification effort. Basically, just this year was launched the recodification concept of civil law. We have a draft law of labor code, which was also mentioned by Mr. Donets, that labor issues are also important in this regard. We also have adopted in first reading the law on joint stock companies, which basically an example of company law, which governs which regulates corporate governance. And it is very important because to this day, we have shareholder primacy concept embedded in this law. But this new law introduces another concept, which is more developed, more advanced. It allows directors in the companies to take into account not only shareholders' interests, but also stakeholders, so wider range of stakeholders. It is a good development, but these issues, for some reason, are not discussed together. And another just great example of this issue is that we have, for example, National Economic Strategy launched in the beginning of March, and in the end of March, we have National Human Rights Strategy. And if you read these two documents, it seems like they were discussed in complete separate processes. Nobody, like people who were working on them, for some reason have not talked enough to realize that they have conflict norms, conflict provisions. And we talked before about this ease of doing business rating. And again, it is an indicator in national economic strategy that we need to be in the top 30 of this rating by 2030. But now there is no rating. So what's happened then? We need another indicator, right? And it's good, in my opinion, because this doing business rating never considered human rights as a variable. You don't need to do anything in this regard. For example, Georgia is at 7th place. And why they have this place? Because they deregulated labor relations to such an extent that they attract many multinationals, but at the same time, peoples are not protected. And the last point. When we talk about Ukraine, we need to keep in mind another important concept in this field, which is called policy coherence. So as I mentioned, we have many directions of development. We need to consider them in connection to one another because they are all interrelated. And we were talking about EU, and somebody told about EU-Ukraine Association Agreement. I need to draw your attention to the fact that according to this agreement, Ukraine has an opportunity to align our laws to EU law, not only to the list which appears in this agreement now, but also to future directives and regulations. It is good news, because when we have this corporate due diligence directive, when we have regulation on sustainable corporate governance, sustainability reporting standards, we can advocate this before our government and ask them to include it into the plan of alignment of our legislation, and then have this all implemented in Ukraine as well, including this update of non-financial reporting, which unfortunately failed in Ukraine to the much extent. And my last point, it is great that we have this forum. I'm truly delighted to be here. But we need to think about sustainable way of keeping this discussion going in between forums. It's like a general assembly of a company here. We need some kind of executive body. We need some coordination in between. And if we have this coordinating organ, it can be, I know, it can be led by state. It can be led by civil society actors. It can be continued to be led by academia, as it was launched by basically one person. And now we have team. We have a lot of colleagues and friends here. We need to think about this coordination, because if you don't talk about it all the time, government is not really keeping attention if you don't push him, right? Thank you.
Thank you very much, Igor. We do believe that at some stage, mandatory human rights due diligence will be part of the region. And thank you for outlining key important stakeholders. And it's good that basically Olena and her team managed to engage now the most powerful stakeholders, such as Ombudsperson's office, ministries, key ministries. And maybe now we would try again to get in touch with Vladislav Vlasuk, no? Okay, yes, because he used to be the former Minister of Justice, key actor in this regard.
I was thinking that you said key habits of minister. No, it's okay. It's just a joke. But I will switch in Ukraine. Я можу сказати про що.
I can tell what Vladislav was going to tell. Hopefully he will connect with us today. The point is that we started to work with Vladislav on business and human rights when Vladislav Vlasuk was the director of the Department of Human Rights at the Ministry of Justice. And jointly with the team of the Ministry of Justice, we organized the first national baseline study on business and human rights in Ukraine. Then, when there were personnel changes in the ministry, and now Vladislav is doing private legal practice, in my view, it was significant and interesting that I know that there are several, but one of the last cases that Vladislav is dealing with is helping the NGO on countering big company on occupying the land plots for production facility for mining without approval,
із порушенням прав
with violation of rights of residents of this local community. And now there is court review of this case, and controlling agencies are responding. And this is the interesting follow-up. Cooperation started at the level of the university and the Ministry of Justice, and now Vladislav implements these approaches and ideas in the legal practice. Quickly, this is what Vladislav was going to tell us. Maybe he will provide more details.
Thank very much all the speakers, all the panelists, and now we have a really few minutes for the Q&A session, and I would like to open the floor for questions. I see already Ekaterina, yes.
I would like just add one comment to what prolonged what Igor was just said about that we have to draw attention of state and speak on this constantly. Yes, and I coming back to our yesterday's discussion about where there should be business case in human rights, and to thesis that Alena said about her interview with Central Asia about the economy in first place and the human rights in the second place. So I think that we have to push this topic on our space in our region. We completely have to, I would have an approach that not opposite business and people, but to understand that today in the era of knowledge economy, of innovation economy, the person and the business is the two parts of single ecosystem. And the security of the person is the security of the business today. Security of the business is the security of the person. And in such countries as post-Soviet countries, and this is our region, it's of crucial importance to develop economy. Because, and that's why they say the first is the economy and the human rights is the second. But the point is that we have to push and promote the thesis that human rights today, not something additional or I mean, that can be on the second place, but the human rights today is a very, very good and effective economical instrument. And actually, and that's why I mean, I don't mean, and we have to define the terms, you know, when we're saying about this business case, I don't mean no way that we have to lower the value of human rights as a concept, no way. And you have to follow human rights only if you have profit. Of course, no. We have to say that if you follow human rights as business and you could help, like you could be in a good way, you can earn more money, and in the same time, you can provide with these better conditions for person's development, for people development, and for your workers and for your consumers. I would choose this approach. I wouldn't oppose the business and society in this region. I understand why such approach have been chosen a bit, it seems to me, in Western Europe, but it's another story of development, and it's another relations between capitalism and, you know, socialism. So that's why here is absolutely another story, because these regions cannot survive without developed business, without strong economy based on developed business. And the person is a part of this. So, thank you.
Thank you, Ekaterina. Yes. Олена, yes, please.
Я б хотіла невеличкий коментар додати. Мені дуже сподобалось
I'd like to add a quick comment. I like to the Igor's points that really many things are available in our legislation, but so far we don't have the systemic vision. For example, if we talked about public-private partnership, one of the requirements, the projects of public-private
навколишнє середовище,
environmental impact assessments and social impact assessment in the region. If we talk about the company which wants to implement the PPP project to build the factory or to do something else. Also, we have requirements in our legislation on environmental impact assessments. This is part of the components on environmental protection and environmental human rights when implementing some projects. Another matter is the implementation of these provisions and the formalistic approach to this environmental impact assessment and the quality of this assessment. But anyway, it is in the legislation. Also implementing the Green Deal, which Igor mentioned, where we expect that companies will also be evaluated in terms of their impacts on carbon footprint. And this is also part of environmental components of implementation of business and human rights approach. So in fact, I believe that the key issue is to explain that we're already doing this as a state, so we're doing this at our level in business as well. Many companies have the policies on ESG, on environments, on social matters, and human rights. We are already doing this, but we need to explain that we're doing this, but we need to do more.
Ці всі частинки, які вже наразі, і їх просто розвивати відповідно до цих глобальних трендів, які є.
according to the global trends which are observed today.
I'd just like to respond to something you said, Katja, about not setting businesses and people on opposite sides. And you referred a little bit to the Western European tradition where you had a feeling that is more the case there. I would say I would disagree a bit with that. I think it started out like that, but I think where it really unlocked this field was when that started to change and diversify. I think when businesses started to work with civil society and sees civil society also as an asset to addressing some of the challenges, it contributed to more transparency and progress in that sense. I think there's a need for all kinds of actors in this field. So you do need your naming and shaming type investigative journalists, and but you also, I think, need the organizations that are working with business. Now, what I would like to caution here is that I think the first people to work with business on this are usually consultancies who are helping business present themselves in a better light. And I think that there's a lot of dangers around, greenwashing, blue washing, whatever washing you want to call it. Human rights due diligence washing was mentioned by Olena in one of the questions. I think here is really the key need for, basically people like us who are working with businesses but come with a human rights background and ensure that certain standards are met when working with businesses, and that it's not just a PR exercise and work with businesses.
Of course, I agree. I'm sorry, I agree totally with the necessity of having all these naming and shaming instruments and legal frame and so on. But just I would like to say, I mean by not opposing business and society, but let's talk to business in moving this topic. I mean, it's not like state and civil society doing something to like punish bad business, I mean, as Beata said in first day, it's not like about when you're talking with business, it's not always that you are talking with some bad guys that, let's talk to business. Let's go to business, talk and ask what do you need to incorporate and implement human rights agenda in your corporate processes, in your business processes. So that's what I meant.
Thank you, Duke. Thank you, Katerina. Now I see that the discussion is so inspirational that nobody wants to finish it. And I noticed one more question from your name. Yeah, please.
Thanks very much. I have a question to Alek and Katja concerning the business human rights in Belarus, but also like about the role of international actors in a country like Belarus, which is perhaps a unique example in our region is a full-fledged dictatorship. And I was also wondering, I mean, how impactful can European actors be in ensuring them business human rights is respected in Belarus? We all know that Council of European Union, which is one of the highest decision-making bodies of the EU, some months ago, adopted regulation on the sanctions on Belarus and in place hundreds of individuals on the sanction list, but also companies like 30, 40 companies. Katja, Alek, would you say that this kind of pressure from foreign actors also contributes to general rule of law in Belarus or to improvement in business human rights, or is just empty threat, just whitewashing of the EU that it can say that is doing something to protect human rights and also business human rights in Belarus. Can this kind of mechanism bring about change?
Just short answer, because it's very complicated actually problem, and our society is divided now on two parts: who is for sanctions and who is against sanctions. Because from the business and human rights, from the political point of view, it's it's one discussion, and from the business and human rights points of view, it's such that I wouldn't say that sanctions is the best instrument for business and human rights. For promoting business and human rights agenda. Why? Because it's pretty technical thing. I mean, if the company is in the sanctions list, you have to cease your relations with this company. And there is no any space for maneuver for using the leverage of your partnership. So, and if you use like in accordance with guiding principles, the leverage of your partnership, you can influence on the situation inside the Belarusian partner. At least you can call on something, you can, I don't know, you can like do something, due diligence actually, because even in accordance with guiding principle, the termination of contract is the final radical measure when you cannot do anything more. But the point is that you have to do all these measures, to improve situation and to try to avoiding of your own risks and protecting at the same time the people and your partner. So, and sanctions is not an instrument for this, but it's the first way is long and hard, and sanctions is very fast and easy in that sense. But still, if we are saying about prolonged effect, sustainable effect, of course, sanctions is not that instrument. It's my point of view.
Thank you again, Ekaterina, and thank you, Yorne. Not to grossly violate our time frame, I would propose to close this session and invite you for the lunch, which is served at the second floor dining hall, and then we will meet with you in an hour. Have a nice day. Yes, at 2 p.m. 2:30.
If you don't want to miss Deputy Ministry of Justice, Ombudsperson Office, Commissioner for Free Barrier Environment, please be in time.